we continue in our goal of trying to make sure that we all completely understand the Administration of Criminal Justice Law 2017. And for the past couple of months right now, the main idea has been breaking this down in ways we can all completely understand it. With this, I want to say a big welcome to another edition of Wheel of Justice. And this program comes to you every Tuesday from 3:30 p.m. It is brought to you by the Acjl State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Plea, with the support of the Open Society Initiative for West Africa, OCWA, and the Acjl State Justice Reform Team. My name is Ifani Awa, and this program, just like I said earlier, is aimed at making sure we completely understand every aspect of the Administration of Criminal Justice Law 2017. I'd love to introduce my guest for today, but before I do that, let me tell you that on this week's edition of the program, we will be talking about the concept of plea bargain under Section 267 of the Acjl 2017. That we're going to try to understand the idea behind the plea bargain. Meaning, we're going to start off from understand what the plea bargain is, and understand why the plea bargain has been added to this law. Now, let me introduce my guest for today, someone who would help us better understand everything about the plea bargain. I'm talking about His Worship John Okpai, who is a Chief Magistrate Grade 1. Welcome to our studio. It's good to have you here.
Thank you for having me.
Right. Now, before we go, we want to take a very quick break. When we come back, we'll dive into our conversation. Don't forget, this is Wheel of Justice.
The Wheel of Justice.
Welcome back. This is Wheel of Justice, and just like I told you earlier, we'll be talking about the concept of plea bargain under Section 267 of the Acjl 2017. And I also said I have with me His Worship John Okpai, who is a Chief Magistrate Grade 1. And let me start by asking, what exactly is a plea bargain?
Thank you very much for that question. Plea bargain. Before I explain it, let me state that plea bargaining is one of the new things introduced
in the Acjl.
In Acjl,
okay.
2014. Before now, it was not really in our procedural law. Plea bargaining is when somebody commits an offense and he's guilty, and he knows that he's guilty, and he doesn't want to waste the time of the court and every other person. He will say that he will confess first. When he confesses, then he will confess to the prosecutor or the prosecuting counsel. Then they will now agree. That agreement will mean giving him a lighter sentence.
Okay.
And most importantly, for him to refund, assuming it's an offense that involves money, he will refund the sum that was part of the crime.
Okay.
But for that plea bargaining to take place, it must be an offense that is punishable on below 10 years. If it is above 10 years, no plea bargaining.
You must serve it. You must serve it.
No, you will now go to trial.
Okay.
You will go to trial. But if it is below 10 years, you will approach the prosecutor or his representative. Then you explain to them. It saves time. It's new to us, but in US, United Kingdom, France, this plea bargaining has been there for a long time. So it helped the state and the victim of the offense. You see, at times when, or most often when somebody is convicted or somebody committed a crime, the victim, the person that his thing was stolen, he will report to the police. The police will make an investigation. They will charge the man, the defendant to court.
Okay.
There, they will convict the defendant. The court may convict the defendant. Then the victim of the offense will go home without anything. Then when the convicted defendant comes out, he will go back and enjoy his loot.
Okay, hold on. Someone steals money from someone else. Then the person whose money was stolen reports to the police, and then normally the police charges the accused, the person who allegedly stole this money, and if he's found guilty of that, he goes to be in prison, but the money stays.
Yes, he still has
the money.
He still has the money.
The person whose money was stolen goes home, and his only satisfaction would be the fact that the person who stole this money has been sentenced. Okay, but right now the law is trying to make it that the person whose money has been stolen can at least get, if not all, some part of the money back.
Most likely he will get all.
Okay,
because when the plea bargaining is being done, it's an agreement between the prosecutor or the prosecuting counsel and the defendant, with the consent of the victim of the crime.
Okay.
Because he has to tell him that I want us to do this thing so that we will not go all hog in prosecuting this matter. And one of the reasons why the prosecuting counsel will take that route is that at times you may not have enough evidence.
Okay.
If he doesn't have enough evidence, but in court you may have a very good case, but if you don't have a credible evidence, the court will not believe you.
So you might have to look for.
So the prosecuting counsel will look for that option of reducing that is making an arrangement with the defendant.
But why would as the accused, why would the accused want to go into a plea bargain if the accused knows that the prosecutor does not have enough evidence to put him behind bars?
No, he would not know.
Okay.
The defendant will not know. You are calling them accused. In this law, we don't call them accused again.
Yes.
We call them defendants.
Defendants, yeah.
Then the defendant will not know that this man or the state does not have enough evidence to convict them, enough evidence to prove the case beyond reasonable doubt.
Okay.
So when you don't have that kind of evidence, and for interest of justice at the state, there are certain cases. If you allow it to go to court, it may bring up a lot of things.
Yeah. So
the best option for the prosecution is to do plea bargaining.
Okay. Now, subsection 2, that is B of 8 states, because subsection 2 talks about where a plea bargain might be entered with a defender. It's trying to explain where it can be done, and B says where the defendant has agreed to return the proceeds of the crime or make restitution to the victim or its representative. Now, what if in a case where the money is no longer available? What happens then? Can a plea bargain still be sought for in that case?
No. It may not. Plea bargaining may not take place because is something you bring to table.
Okay, you have to bring some to the table.
To the table for the agreement, because those things you are going to agree on will be put into writing. You sign, he will sign, then it will be taken to either a judge or magistrate, the magistrate.
Okay.
So if you don't have the proceeds or the money, there's nothing for you to bring to table. You will not go in. You will not go to plea bargaining. Another aspect, if it is conspiracy.
Okay.
Assuming conspiracy is an offense where maybe two or more people agree to commit a crime. In that case, it is an agreement. That offense is committed once the defendant agree to do that illegality. Okay. So in that case, there's no proceed for him to bring to table.
Okay.
Assuming they go for plea bargaining. What the prosecuting counsel or the prosecutor usually do is to bring this person. He will give us evidence to convict the other ones. He will give you a credible evidence. And as I said, one of the reasons is that when the prosecution does not have enough evidence to prove the case beyond reasonable doubt, and most often the defendant will not even know. The essence of this plea bargaining is more or less to restitute the victim of crime.
Okay. Now, because of time, we've got about less than 30 more minutes on the program so far, and there are large areas to look at in this section of this law. Now, I want to go to the subsection 4 that states the prosecutor and the defendant or his legal practitioner may, before the plea to the charge, enter into an agreement in respect of the term of the plea bargain, which may include the sentence recommended and within the appropriate range of punishment stipulated for the offense or a plea bargain, plea of the guilty. Now, let me just ask my question based on this. Does this mean when the defendant enters into a plea bargain, can he suggest the number of years he would want to spend in prison?
No, the defendant cannot, because the law has already stated the offense, the offense and the punishment that will be discharged for the person that committed that offense. He cannot state it. Rather, the prosecution usually bring down the punishment to entice the defendant. Yeah. You entice him, say, because it's an agreement. You do this, I'll do this. I don't know what I'm making.
I get your point.
So if it is 10 years, you cannot say no. They will say that okay, let's do 8 years or 5 years, then refund these things.
Okay.
In fact, they even allow you to go. Let me tell you that EFCC, they've been using this
plea bargain
for most of their matters. That is why when you see all these top shots, when they are charged, after a while you don't see them again. They do the plea bargaining. They will say, let me bring this amount, let me go. Even houses, they will give them the title deeds.
Wouldn't this doesn't this look like someone is avoiding or justice by doing this? Like they committed an offense and then they are let go just because they returned the money.
No, in the sense that the law that prescribed the punishment will say 10 years or 5 years. The court is not bound to give that 10 years. The court can give less than that, or even caution and decide discharge. Then, most importantly, which some of us don't know, for the state to prosecute a matter in court, it involves a lot of things. You have to pay the prosecutors.
Okay.
You have to see that the judge or magistrate is seated there. The other things. So it will be cheaper for the state to go for plea bargaining. Then you now recoup whatever the person has taken illegally.
Okay. If you're just tuning in, this is Wheel of Justice. It's a program that helps us better understand the administration of criminal justice law 2017, and it's brought to you by the Acjl State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action, that is PRAWA, with the support of the Open Society Initiative for West Africa, OSIWA, and the Acjl State Justice Reform Team. We're talking about the concept of plea bargain under Section 267 of the Acjl 2017. I've been speaking with His Worship John Okpai, who is the Chief Magistrate, Grade 1. We're going to take another quick breather. When we come back, we'll continue our conversation. We'll try to better have a good idea of everything that has to do with the plea bargain. Welcome back to Wheel of Justice. It comes your way every Tuesday from 3:30 p.m. My name is Ifeanyi Awa. I have with me His Worship John Okpai, who is a Chief Magistrate Grade 1, and we've been talking about the concept of plea bargain under Section 267 of the Acjl 2017. Now, basically, he's given us a ground understanding of what the plea bargain is, why it was brought up, what it entails, and we'll still continue. There are other aspects we might still have to look at. But if you'd love to ask a question, based on this plea bargain, the angles you would love to get a better understanding of, he can also answer you. Our numbers are 0808 182 6949 or 0811 605 2949. Again, 0808 182 6949 or 0811 605 2949. All right, now just like what we were saying during the break, basically we have a good understanding of what the plea bargain is right now. The idea is to make sure that there's restitution for the victim of this crime, so it doesn't just go away without getting anything from this. Okay, now let's see if we can look at other parts of the section that can also come be helpful. Now, on that angle is that the judge of the case would not be involved in the agreement between the prosecutor or the defendant. Is this right?
Yes. The judge or magistrate will not be involved in the agreement. What happened is that the prosecuting counsel or the prosecutor, with the consent of the victim of the crime, will fix a meeting with the defendant. They will now, with the defendant or his representative, they will agree on terms. Those terms will be reduced into writing. After that, they will now take it to the magistrate or the judge.
Okay.
Then the judge will look at it. And plea bargaining can only take place immediately or before the defense open their case.
Okay.
In court, the prosecuting counsel or the prosecution will first lead the evidence. So after leading the evidence, at that point, plea bargaining will start, assuming the defendant want to show remorse or whatever. Then, but once he open his defense, remember that once he open his defense, it means that he's no longer guilty. Before the prosecution evidence, he pleaded not guilty. Then once the defense open, he's no longer guilty. And whatever agreement they reached at that meeting will not be used against him during the court trial. You cannot say that, hey, when
he said this and they said that.
He said that, you will not use it.
Okay.
The matter will start de novo before the magistrate or the high court judge.
Okay, now two questions I want to ask, hopefully before we run up, because we're almost out of time. Number one is, can a judge reject an agreement brought before him by the prosecutor and the defendant?
No.
If it feels maybe whatever agreement reached, he's not comfortable with sentencing, agreed.
Okay, if he's not comfortable with the sentence or the number of years the person to serve, what he can adjust it, but he will not reject the agreement. Okay. The reason being that if victim of offense or parties to an offense say that they are no longer interested.
Okay.
So what are you going to do?
Okay.
Who will give you the evidence? Granted that section 125 of criminal code said compounding felony.
All right, quickly, let's go. Hello, good afternoon.
Yeah, good afternoon.
Good afternoon. What's your name? Where are you calling from?
I am Joseph Ejindo. I'm calling from Alayaman.
All right, Joseph, go on with your question, please, quickly.
My question is this: what if a victim in the court refuse the plea again?
Okay.
Maybe the accused person have understand that really he committed an offense and he defended himself. Then he asked for plea again. Then if at all the victim refuses to accept plea again, what will be the position of the matter?
Okay. All right. Thank you very much, Joseph. So did you get a question? Can a victim say, you know what, I don't want a plea bargain?
You remember when I started, I said that the plea bargain initiated or whatever by the prosecuting counsel or prosecution must be done with the consent of the victim.
Okay.
You cannot go on your own. It's not your matter. You cannot go on your own to agree on a plea bargaining when the victim is not carried along. You must tell him, and most often he will be in the meeting, either himself or his representative, probably a counsel or any other person, assuming he's hospitalized or something. You cannot start it, conclude it without his consent. It's not done.
Now, I'm going to ask one last
question. Because he is the nominal complainant. In as much as the offense is committed against the state, but the victim is the nominal complainant. He is the one that will give evidence to convict or not to convict. Okay. He will, if he gives a credible evidence, the person will be convicted. If he does not give credible evidence, the person will not. That is why when a victim says that I'm no longer interested in this matter, there's nothing you can do. In as much as I said, 125 of criminal code provide for compounding felony. That is if you're colluding to commit an offense. But if you insist on going on as a judge or a magistrate, nobody will give you credible evidence for you to go on. So there's no how you can go for plea bargaining without the consent of the victim.
Okay. Well, I wish I could continue this conversation, but we are out of time right now. Well, anyways, I want to say thank you very much to His Worship John Okpai, who's the Chief Magistrate Grade 1. I can see more calls coming in, but we are out of time. Can't take any more calls right now. Thank you very much for coming through. I really enjoyed having you here. Thank you very much.
Thank you for having me.
All right.
I appreciate.
All right. And don't forget, this is Wheel of Justice, and it is brought to you by the Acjl State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Prowler, with the support of the Open Society Initiative for West Africa and the Acjl State Justice Reform Team. And I want to say thank you very much for being a part of this. My name remains Ifeanyi Awa. Till next time, please continue to obey the law and please be enlightened about the law. Do have a great day ahead.